Hold on a second. Let me put that link together right quick so I don't forget next time. Y'all can listen to it in the meantime. All right, 1 second. Ah, it's being used. Hang on. Close this out first. There you go. Up. Man. Upload it. All right. Here you go. Oh, wait. That's... No, we're removing that. What the fuck? What the hell? Did not need to do that. Please ignore that. There you go. I'm not doing a Jeffrey Toobin, okay? Oh my god. There we go. One second while I put everything together. Oh. Well, here's the thing. Hey, what's up, Deacon? While you guys, I mean, I don't know. I know my those who follow my gaming channel know this, but one of my earliest viewers, he's no longer watching. I know he's still around. He drops in every once in a while. But he actually made songs for me. Like, I think he's now back in college. Or or that's why he stopped watching me. Like it was like back in 2018 or something like that. But he actually made tracks using sound bites of my live streams. Here's one of my personal favorites, right quick, and then I'm just posting this while I get everything set up.
Hell, right in the kisser.
These are all from my live streams.
Wisdom. Sophia, best girl. Life and material. 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 Do I look like a cam girl to you?
Leave me alone.
I need this for drugs. My fortress of solitude.
Okay, absolutely, Deacon. I did not ask for it. He just randomly decided to make these tracks for me. He also made a lot of my emotes. He made them for me. I didn't ask for them. He gave them out. I mean, I would have happily have paid him. He didn't want anything. So, you know, it's all thanks to him. All the best to him. You know, I miss him. A lot of us miss him. But hey, he's got to do what he's got to do, right? But Steven, if you're out there, I always appreciate it, man. Tracks. All right, we're almost ready. I'm sorry, I'm kind of flustered. I had finished my run earlier, just finished taking a shower, eating dinner, and I figured I was gonna do one last stream before I leave on vacation. So that's why I'm here. Where was it? One last track, and then we'll get this party started. Yep, vacation. Yeah, no. Oh, this is my ringtone. By the way, this is my ringtone. I've had this as my ringtone ever since he made this track for me.
What's going on, everybody? Who is that cat? Arthur. You're just gonna stare at me? Oh. I am, rollers. What the hell?
Yeah, I just had this a carpet vacuum cleaned because they like to vomit.
Unless if you meet special
Moving on.
What special conditions?
What's that? I just started the stream. Andrew, I did see the video, or excuse me, I saw the link. I haven't seen the video yet, Andrew, but I will take a look at it later. But I wanted to take care of Mr. Estabrook because I forgot that he has a lot of his courtroom hearings as well. But I want to start out with this so everybody has the context of why he's in court. And it's fitting considering I'm going to be heading to the airport tomorrow morning.
He wants to know what special conditions allow a person to go through.
But I'm going to
Usually just chill there for 75.
get a drink.
Or if they're pre-checked.
So you're aware that you guys do not have the right to discriminate based upon age? Because that's the same as racist discrimination. That's the same as gender discrimination.
Not all ages are protected by constitutional requirements, but it's actually only over a certain age.
I'm sorry, but I don't recognize the Constitution as protecting anybody.
Very good.
I'm born with my rights. Are you not? Do you believe that a document that was signed over 200 years ago gives you rights?
So here's the thing, I've given you 3 opportunities here, and you got a choice. If you would like to go through AIT, of course it's an option to you. If you choose not to do that, you can do the opt-out. With that, I would give you the advisements far before.
Yeah, if you don't know yet, the reason why he doesn't want to go through the metal he doesn't want to go through the scanner because he thinks it's going to turn him radioactive. He also doesn't want to go through a pat down because he thinks he's going to get molested. So he says he wants to go through the regular metal detector, which at this time that was reserved for the elderly and young children, like children under 13 or something like that, or people with disabilities, something to that effect.
Before we go
AKA not him. He doesn't qualify.
there, so you know what to expect. And if you choose not to do that, you'll have to make other arrangements.
Is there a way that I can get out without having the risk of cancer upon my body and without getting sexually molested?
Well, that's your interpretation.
Would you like somebody to touch your balls? Is that something
I've
that
been
you...
through the pat-down
Okay.
procedure.
Balls.
How did that feel?
It really didn't bother me that
Okay.
much.
Well, you've probably never been a victim of sexual molestation,
You're
have
right, I
you?
haven't. So
Okay.
I wouldn't understand what that was like.
So do you realize that you force several thousands of people every day who have been a victim of that to undergo a traumatic pat-down, as you call it, when really it's just a molestation?
Okay. So the choices here are clear.
And
if you
the
go through
website-
the AIT, I mean, I'm not going to try to convince you that it's safe. I'm not going to convince you that it isn't. You have the information that you can read right there that tells you exactly what risk levels are available to you.
Well, you guys even lie about the risk levels.
I don't lie about anything.
Well, the website lies, and you are here as a representative of TSA, and you're so.
I honestly feel bad for the worker because he's nothing but cordial and courteous with him, and he is generally an asshole.
So I expect that what comes out of your mouth is what TSA is saying to me.
What
right?
is TSA saying there? What you told me that makes it a lie?
TSA is saying that the imaging that they use is non-ionizing, and there's no way that you can determine that because each person is different, and the level at which the radiation may ionize within somebody's body can be different for different people.
Okay, and that is a claim that you're making. Do you have something to substantiate that?
So you have
And even if that was true, do you have anything to back up the idea that somebody can be affected by the radiation so much that it would be a genuine health hazard? And if so, why haven't you gotten that checked out, gotten some sort of authorization, some sort of slip, something authenticating that claim?
no way
So
to
when you're
ensure.
standing outside, you consider that the radiation,
And again, the alternative is the pat down, which I've gone through the pat down. Do I enjoy it? No, I'm not into that. But would I call it molestation? I think you're kind of stretching there a little bit. I don't think I would call it molestation. The last time I got I gone through a pat down at an airport.
the radiation risk level of being outside is too great to be outside.
There are times where the sun does use ionizing radiation,
When you're
but
aboard the plane-
that is a choice.
When you're aboard the plane and they say that it's equivalent to a certain level of exposure Do you
I
feel
haven't heard that.
risk level is
I
too high?
haven't encountered that. I have concerns with the body scanner technology.
Well, I'm only saying it because obviously there's a certain degree of risk in everything we do, right?
Yeah.
This has been determined safe as by the evaluations that have been, both the safety evaluations and the testing evaluations have determined it safe. I have no reason to discount that as anything other than safe. You've made a determination that you're allowed to make, which is you're not comfortable with it. Okay.
And your website
that's
indicated.
more than fair. It's more than fair. I wouldn't tell you that you're wrong for having that personal view.
But listen for a second, please.
I am listening.
I bought my plane ticket with the understanding from your website that I could either choose to go through a body scanner or I could choose.
I didn't see where it was giving you an option of a metal detector.
It said the two options that you use.
No, it says the two devices, two pieces
two
of equipment.
primary methods of security screening. So there was nothing in there which indicated only people of a certain age are allowed to go through the metal detector. There was nothing that indicated to me that I would not be able to go through a metal detector. So I bought a plane ticket, which is non-refundable, under the condition that I would be able to pass through a metal detector.
Well, maybe before getting that non-refundable ticket, you'd, look ahead and see what was going on.
So now you're trying
God damn it, Nathan.
to limit my right to travel.
At this point, is there anything I can do to end compliance with this, or are we just done?
I can file a lawsuit against you.
Well, you're welcome to do so, but I can't.
Well,
I can't spend any more time debating it because I have no authority to debate the procedures. I cannot make an exception for you to screen you differently based on your viewpoint. What I can tell you is these are the two options that are available to you. There are no other options that I'm able to offer you at this point in time.
Well, if you walk away, I'm just going to go through the line and try again. So I'm going to do this, and next time I won't stand out of line. So we need to come to a determination here because you are limiting my right to travel. You are making it so that my ticket, which I paid for, is void because I can't use it if I can't get on the plane. So are you going to recompense me for that cost?
No, he's not obligated to do that. He's obligated to follow the rules and guidelines that he's been taught. So no, he's not going to personally refund you or get TSA to personally refund you.
Since it's your fault, since your website indicated
It's not his fault.
that I could use a metal detector, I mean, you can either let me fly or you can give me my money back.
Well, those are neither of the options that are available,
Why?
as I just told you.
Why is your website a lie?
It isn't. You just read it to me.
Yes.
And you just said that you never said in there that that's an option available to you.
Okay. It never said it wasn't. It did too. It said the two
It didn't say
security
that
methods.
was an option for you.
It didn't say that the body scanner was an option for me either.
It did say it was a primary.
It said that they were both primary methods.
Right. They're both primary methods. And the only time you can take the plain old metal detector is based on age. And I hate to break it to you, but age is under intermediate scrutiny, not strict scrutiny like race, I believe. Oh, damn it. Race, religion? Is religion also? I know sex, gender, sexual orientation are intermediate scrutiny. I think race is strict scrutiny. Ah, damn it. I can't remember.
If you want to read it again, maybe we could do that, or I could pull it up. But I'm really not going to debate it with you. It's
Go
not
ahead
my
and pull it up
determination.
and either give me my money back or allow me to pass through and fly.
You know what I think? I think that this is a great opportunity for you to make something out of this situation. And I don't feel that you actually are interested in following through with going through either one of those options because you said that you're not comfortable with them. So I really can't accommodate anything else myself. So I told you what your options are. You're not choosing those. So I'm done talking with you at this point in time.
Okay.
Hello, Archangel.
Go through the metal detector then?
No.
Oh, well, how can I get to my flight then? Show me a pathway so that I can go to my airplane, which I paid for.
You've already been given the pathways, either through the main screening or pat down. Those are your options.
Or give me my money back.
If you want your money back, go talk to somebody else, because he's not. I don't think he's probably authorized to do any of that, and I don't think TSA is going to refund you anything. I mean, it's TSA.
Well, I'd be happy to walk out and put a good word in with the airlines, but I don't determine that. That's not.
This is 2016, Deacon. This is 2016.
I have no say on. That's a private.
I'm still going through the Oktoberfest that Jeremy sent me.
So would you like to walk with me back to the airline and see if we can get them?
That's what I thought. Religion and race is strict
can't,
scrutiny.
Then I'm going to come back and attempt to pass through security again.
Well, that would be up to you, but I'd be happy to go out with you.
Doug, I'm
see what they're
because almost all the beers you gave me, Doug, are like 9 to 10%. I'm gonna hold off until trying those until I get back, because I kind of need to like wake up in the morning. So
do. I mean, it's their determination ultimately.
Well, isn't it your fault?
Well, it doesn't. I don't know at this point.
how is it his?
It matters who's at fault. What matters is getting you a resolution to your situation.
Okay, so you're so you're willing to put in a good word to the airline, and if their policy says they can't, then will TSA refund me?
I'm going to hope for the best on this.
Okay. You're not going to leave my side, are you?
No, I'll go out with you.
You promise?
Absolutely.
Okay.
I'm good for my work.
Let's go.
No.
So, just going to brief the officer real quick.
How's it going?
Good, how are you?
Good. So what's up?
This guy isn't letting me go through the metal detector like the website said I could, and he is telling me that I either have to go through a cancer-causing body scanner or get molested before I can get on the plane.
Well, I
which
don't think
fly
he
for.
said you had to get molested.
Well, he calls it a pat-down, but that's a euphemism for sexual molestation.
Okay, not in my experience, but
Have you ever been sexually molested?
I've gone through the checkpoint.
Have
many
you ever
times.
been sexually molested?
No, I have not.
Okay.
Well, all right. So we're going to have to go through whatever scan they choose you to go through, and you're going to have to go through a pat down.
Okay, I'm not getting a pat-down, and I'm not going through a cancer-causing
then,
thing. Well,
right, then we're out of luck.
Well,
So at this point, what I've told him is that the primary means of screening is the AIT. That he's more than welcome to go through that. He doesn't want to do that, which I said is his right. Then he has the alternate option, which is opting out. He can opt out.
Right.
And then he'll be subjected to a pat-down. He doesn't want to do that. And I said, well, at this point, there's a third option, which is he's more than welcome to leave. His concern around that is he already paid money for his ticket. I said, I'd be happy to go out. I said, this is their choice totally. I'm not saying the airlines would do it. I'm happy to go out with you, put a good word in for you. Maybe they'd be willing to refund your money. Maybe they won't.
What airline is it?
Alaska.
Okay.
But figured we could go out there, and if that's what...
Well, I feel like it's kind of both with this guy. I'm not saying he's faking that he has a ticket. I think he does have a ticket, but we all know that this is a shtick for him.
If that's what he's comfortable doing, is saying, I just want my money back, and I'll go do something else. I mean, I'd be happy to help that process along. I mean, I don't want him to be...
What's my favorite beer?
He's forced to do anything.
I feel like you're limiting my right to travel.
Shiner.
Which is my right as a native to America. And
Okay, and everyone
Hey, Gary.
some sort of security.
Well, not everyone.
Or Arty's
because-
first beer on
I'm
his
willing
flight to
go
make him
through
feel
the
better
metal detector, and
about going through the
they told me that
cancer-causing
people at
device.
certain ages are
Thank you,
allowed to
Gary.
go through the
Much
metal
appreciated.
detector, and I believe that's age discrimination. I believe that they're not legally allowed to
Okay,
participate in age
right now-
discrimination.
right
Please
now.
don't interrupt next time.
Right now, we have option A, which is to go through the scanner. Option B, which is to go through the pat down. Or option C is we'll try to get you a refund and you can find another means of travel.
And why does the option that is listed on the website, which is use the metal detector, why is that taken away from me?
I'm not going to really speak to that. I mean, first of all, like, we looked at the verbiage of it. That's not how
I have a cat sitter, John.
Verbiage. It is how
I haven't had Rolling Rock in a long time. I got no complaints about it, though.
That anybody, I'm not saying, I wouldn't think that most people would interpret it that way. I respect your perspective, but I'm just saying I don't interpret it that way, and I don't think it's indicating that at all. It didn't sound like that when you read it to me, and from what I know on our knowing the procedures, that's not what it indicates in any way.
Are you aware that it is unlawful to discriminate based upon age, race, or gender? Are you aware of that?
I'm also aware that Article 16 special needs searches gives certain parameters that say that this is a little bit different than your normal search and seizure out in the public, right? This is different. So there's been Congress has given legal parameters that are different under this environment than they are outside this environment.
So then why can you not use your authority and wise judgment to allow me to pass through a metal detector, which is, I know to be safe. You can screen me adequately.
What was your first name?
My name is Robbie.
Robbie. All right. We're not getting very far. No matter how long you stand
Well,
here.
I want answers to the questions.
Okay, well, they're not going to get answered here. And no matter how long you stand here, the options are still going to be A, B, C. There's not going to be a D. There's not going to be an A1.
And why are you speaking for TSA in this matter?
No, I'm speaking for the airport.
Yeah.
How do you represent the airport?
Portland?
Okay, it says Port of Portland Police. I assume that's
Correct.
City of Portland?
Port of Portland.
Okay, what's that?
Really?
Okay, so you have
The authority to remove you if you do not
Yeah.
are not willing to go through screening.
You don't have the authority to remove me.
Yes, he does.
No, I do.
No, you don't. That would be assault.
No, it wouldn't be assault.
No.
Assault,
Yes,
it would
it
be
is. I'm in a public place.
okay.
My God. Why? Why do these people think that just because they're in a public place, they can do fuck all anything they want? Just because a place is classified as a place of public accommodation does not mean you can do whatever the flying fuck you want and not have your ass get thrown out.
Right now, just pay attention. If you want to record it, record it. Since you're not willing to go through screening,
I am.
they've given you the options. You're not willing to take the options they've given you. So
I am.
Are you going to do A or B?
I'm willing to go through the metal detector, which is
All right.
listed on the website.
Done. You're not willing? No, we're done. I'm telling you, I'm giving you a lawful order as a police officer that you have to leave.
Well, I don't recognize that authority.
Okay.
Why?
Let's try number 2. Right now, you are not allowed to be here.
Why?
You're not going through the screening process. I'm giving you a lawful order to leave, or you will be arrested for trespassing.
Why am I not allowed to
Robbie,
be here?
are you listening to me?
I am. I'm asking
Because
you
you're
questions.
not going through the process. You'll have to walk out here.
Are you attempting to not listen and answer my questions?
Would you like to walk out here now?
I would like to go on my flight, which I paid for.
61.
Please.
And we're done. Okay, so yeah. So let's go now to his arraignment for said incident.
930 Robert Estabrook.
Let me make sure the volume's up.
I'm sorry, objection, point of clarification. I'd rather.
Oh,
not,
by the way, he is a Marc Stevens adherent, if you hadn't realized.
hearing because I don't quite understand why I'm here.
1 second.
Okay, go ahead.
With the peace officer, if you look up this, the law says you're not inside anything today, we still get the case started. When you have the right to represent violence, we're already appointment for you at no expense.
Objection. I would rather.
Well, you can talk to her first.
I would rather not. I actually have some questions that I would like to ask you about the cause and nature of this hearing.
Well, that's part of the reason we're going to set it for another day, so you're trying to ask any questions you might have. Your lawyer, if she won't answer your questions or you're not satisfied, then why don't you tell me next time?
With all due respect, I feel like I'm here under duress, and I would rather take care of this matter today. I have an unsigned plea of guilt.
Unsigned plea of guilty. I mean, I could theoretically, I could probably make a bingo just for Marc Stevens' adherence.
That I'm prepared to submit today, but first I do have some questions.
Well, you don't have time for that today, and that's why we want you to talk to lawyers. You can give you advice about those questions.
Objection. I do not wish to speak to an attorney. I have some questions about the cause and nature of this hearing that I would really like to have answered right now.
That's the purpose of having a lawyer. After you talk to her, if you're not satisfied, we'll talk some more about whether you should represent yourself. But we're not going to do that today.
Are you refusing to let me have an informed hearing? Should be informed of the cause and nature?
Keep yourself in the foot by going to break the case, but I want you to talk to lawyers first. And then you have to give advice, and you have kids ask questions. If you're not satisfied with the answers, you can talk to me next time. But if you're going to get your case started so that you can get more information, police reports, legal advice, there's a lot of things you need before you...
Sir, do I have the right to a fair and meaningful hearing?
You do. And you have time for that. So
Objection. Point of clarification. I do not wish to move this forward. I would like to ask these questions today
Yes.
to gain an understanding of this hearing.
A lot of the questions that he's asking are part of Marc Stevens' script. Do I have a right to know the nature and cause of the proceedings? Do I have a right to know the to be informed? To make an do I have the right to plead guilty? Do I have the right to make an informed plea of guilty? These are all questions in Marc Stevens' script, like to a T.
And I do not wish to have an attorney today. I do have some very important questions that I would like to ask.
Why are you needing an attorney?
Objection.
Mr. Estabrook?
Are you saying that I do not have the right to represent myself?
I'm saying not today. If you get some legal advice and think about it and make a knowing, intelligent, voluntary decision later.
Objection. Point of clarification.
You shouldn't rush through something like
No.
Was that a no?
It's not today.
Archangel.
On March 16th at 9.
Objection. I do not agree to
It's
this.
no different from a security guard telling somebody to leave a bank if they don't have any business being there at the bank. Honestly, your comment doesn't really even make any sense to me, to be honest. I don't have this idea of the officer. How is the officer trespassing on Robbie? And how would the airport need to trespass on him? He's the one who's at the airport. He's the one who's entering the airport. The airport is giving him, a conditional license to be on the premises because he has a ticket. He's going there to go on a flight.
It's the way you want, but we need to set your case another day.
Objection. Point of clarification. I don't understand why you are attempting to extend this matter when we can.
I don't think I've seen that one, Andrew.
I don't believe that's a relevant question.
Well, you could be asking for jail time in this kind of case. You need to talk to those attorneys.
Objection.
All your questions are overruled. We're setting your case for March 16th at 9 o'clock.
Objection. Point of clarification. May I have the grounds for your reason to overrule my objection?
No. Judge doesn't really have to give you basis for overrule. I mean, he can get in trouble on appeal, but that's something for on appeal. So the judge here is not really. No, the officer is threatening to escort him out of the building for trespassing, and that escort can involve him physically removing him, putting his hands on him. If you consider that to be trespass, we have different definitions of trespass.
Objection to be informed of the cause and nature of these hearings. Objection, point of clarification. I don't feel like we can move forward with this trial until I've addressed certain issues.
Exactly why I think we need more time to find out about this. So your point makes Marc.
Objection, a point of clarification, sir. I am here under duress, and I do not wish to move this case forward because I believe that it can be handled today. So I'm asking you some very pertinent questions. Do I have the right to be informed of the nature and cause of the charges against me? Am I entitled to respond to the answers to questions I have about these charges?
Yeah.
Okay. The objection, point of clarification, was that a yes or no?
Again, the whole point of clarification, another classic Marc Stevens thing.
Basically, misdemeanor charges. You're telling me you never represented yourself before.
Objection, Your Honor. Are you saying?
I said, listen, I'm not going to talk to you. District attorney can ask for jail time. You definitely need legal advice. And even if you can represent yourself, you shouldn't rush to any decisions today. So we're not going to finish your case today. We're just getting it started.
Objection, point of clarification.
I'll have to call your case later today or a different day. Anyway. Because other people are basically waiting for me to call their cases. And I can't emphasize to you enough the importance of talking to lawyers before you say anything more about your case or making any decisions about it.
Exactly.
Are you attempting?
You're wasting everybody else's time by obfuscating and being intentionally
I'm
obtuse.
trying to understand. I just have some questions that I have.
Well, that's the thing. That's the thing, Deacon. A lot of the tactic here is circular, is being completely circular. You notice that in other incidences, another Marc Stevens adherence incidences, where they constantly re-ask the same questions over and over and over and over again. Informed plea, jurisdiction, nature and cause. I just have some clarifications. Over. It's intended to both stall, and also antagonize the judge. Because I remember watching Juan Galt's thing, where the idea is intended to make the judge look bad, make the prosecutor look bad. So their tactic is to be calm, be that sort of like passive-aggressive attitude, but ultimately it's to obfuscate and waste everybody's time.
Objection. I do not wish to have an attorney. I do not wish to speak to him.
Have a seat in the back of the courtroom.
All right. We're skipping to 1450, which is when he gets called up again. Yeah, he ends up waiting until the end of the docket.
It's important that you're very aware of how serious this is. The state of Oregon is charging you with 2 misdemeanors, each of which involve the possibility of jail time. So it's essential that you understand all your rights and not do anything today that would jeopardize your freedom or have any other issues. You were asking a lot of questions earlier. What I'm trying to explain to you is that one reason you have a lawyer that can answer your questions. If you're not satisfied with their answers or you want more information, then you can come forward. All of these days when your case is started. Now, I think you get started. I need to be a lawyer for you.
I object to that. I object to the...
I'm not done talking to you. After you've had a chance to talk to the lawyer, meet the person, find out what they have to say, ask any questions that you have, you're in a better position to decide if you want to hire your own lawyer, you want to represent yourself, you want to ask for a different appointed lawyer. But until you've had a chance to ask those questions, it's not appropriate to make any decisions today. So what I'm doing is giving you a chance to find out more about your case. And you can research your case yourself and bring up your own issues, but we can't do that all today.
Objection.
As you know, there's no jury in the room. If you want to have a trial, we have to schedule it a different day. If you want to settle your case, we have to do it a different day. We're not going to settle your case today no matter what. So I would suggest to you that you take advantage of the legal advice. You're in a better position. Maybe you can actually answer the question.
Do I have the right to plead guilty today?
Only if I'm convinced that that's a knowing, intelligent, and voluntary decision under the law. I'm not allowed to accept your plea unless I can make that finding. So unless I'm convinced that you know exactly what you're doing, I'm not going to accept your plea today.
So was that a yes or no?
It's a no, because I have not yet heard from you that you have any legal training or experience, or researched the law in these cases, that you've read the police reports, that you have a good understanding of what you're doing.
So to be clear, are you saying that today I do not have the right to plead guilty?
Not today.
Not today. You haven't made it clear that you know what you're doing or know what you're talking
All
about.
the elements of the charges against me.
Oh, here we go.
Does the prosecutor have the burden of proof here today? Is jurisdiction an element of the charge?
Again, back to the script. Am I innocent of all the elements of the crime here today? Yes. Is the prosecutor does the prosecutor have the burden of proof to demonstrate, to show all the elements of the charge?
Charges against me?
Is jurisdiction one of the elements of the charge? But as Juan Galt mentioned,
Has the prosecutor submitted factual evidence which proves beyond a reasonable doubt that the entity calling itself the state of Oregon has jurisdiction over?
now you done fucked up, because jurisdiction, demonstrating or establishing jurisdiction is not, the burden of proof for jurisdiction is not beyond a reasonable doubt. Period. Jurisdiction has a very low bar. All they need to show for jurisdiction is that you were charged in the state of Oregon with X crime. You were witnessed doing this here in the state of Oregon, aka the Portland International Airport, and all they need to have is that being in the affidavit, in the charging instrument, in the probable cause, or the probable cause affidavit. That's it. That's it. Now, the jurisdiction, that is as what Juan Galt said, that's a prima facie establishment of jurisdiction. He can challenge it by saying he's like a foreign diplomat, like a lot of these more sovereign citizens like to do, or that he has some level of immunity from prosecution that, we don't know, that this court's going to recognize, or that, as a matter of fact, I was actually charged in Seattle instead of Portland, or this incident happened in Seattle instead of Portland, something crazy like that. Then he has something to challenge the jurisdiction. But all they need to show was that this occurred in the territorial boundaries of the state of Oregon. Boom, we're done. Thank you. Have a nice day.
That's one reason we talk to lawyers. We follow police reports that they'll provide to your lawyer, and they'll go through those reports with you.
Are you saying that we can proceed when there is a question of jurisdiction?
I'm saying that that's the kind of issue you would bring up at a future court hearing.
Exactly.
I point of clarification. Are you saying that we can move forward with this hearing when there is an issue of jurisdiction?
Here's the thing. There is no issue of jurisdiction. That's what I've been saying. It's a rebuttable presumption of jurisdiction based on the charging instrument. It's a rebuttable presumption. It's on you. The burden now shifts to you to make a motion to challenge said jurisdiction. You haven't done so yet. That's what the judge is talking about, how that needs to be heard at a different date. So he's like, there is not a question about it right now. You haven't filed the proper motion to challenge jurisdiction. Again, we're at an arraignment. We're not even at a pretrial motion at this point. We're simply at an arraignment.
An arraignment, and if there are issues about jurisdiction, you're aware to raise those. In fact, we're standing next to you is going to assert your right to raise legal challenges in the future, but we want you to get a chance to talk to lawyer first.
I object to having an attorney. I object to any counsel at this point.
You're coming back to court in this regard.
So you are you forcing an attorney upon me?
For the time being, yes. Yes.
On what grounds?
Ah!
You can ask her attorney about all these questions. So her number is right there, so you should call her and set her up an office visit so you can talk to her about all these things. But all we can do today is complete the arraignment, and if there's any issues you want to raise, you can raise that next time.
Objection, point of clarification. I don't feel, I don't understand.
That's
Why
all.
are you?
Understand something you talk to lawyer, we'll talk about it next time. So what is the court think? March?
Objection.
Oh, you need to stay out of the court and airport unless you're there.
Objection, point of clarification. You are attempting to move this, are you attempting to move this hearing forward without my consent and without evidence of jurisdiction from the prosecutor?
What I always do is preserve your rights and give you time to think about everything and make any decisions.
Has the prosecutor submitted evidence of jurisdiction?
They filed the charge. That's all they need to do at this point. If you want to challenge jurisdiction, you file a motion and make it appropriately.
So they have not, are you saying they have not filed evidence of jurisdiction at this point?
Okay, so this one, oh, by the way, I already tried the first red gap earlier after my run with my group. It was a Hefeweizen, and it was really good. So this is the other red gap that Jeremy sent to me, and it's the Big Chief Bach. So I'm gonna be interested in trying this one out. But I did like the Hefe that I tried earlier.
These are all questions you should ask your lawyer.
Oh my God, Jeremy, throwing out those dead memes.
That's not what I'm asking. I'm asking, has the prosecutor submitted evidence?
So basically, they're trying too hard and might have walked into. I think that the problem, and this is where I will critique the judge, because I do think that ultimately he does get under their skin. Even though I think they're still in the right, he does get under their skin, so I would imagine he would call that a victory in his eyes. But yeah, the way he does these things, you could tell it's a ploy. He's not actually being genuine in anything that he does.
Was that a yes or no?
Sure. There are a lot of questions in our...
Yes, Gary. We were talking about that on my run. Yingling's chocolate beer. I heard it was really good too. I have to look for that.
Did I ask you earlier if I was entitled to a responsive?
Terrible.
So is there something
I'm
that
not going to
changed?
answer any more of your questions. Is that clear?
So, Mr. Estabrook, what we're here for today is an arraignment, which is a formal charging. You're getting an attorney appointed. Talk to your attorney.
I object to that.
I object all the time, and the judge overrules me too. So
Yep.
We'll talk about that with the attorney. Since you're true legal name spelled correctly, so.
I would rather not speak to an attorney at all, and I am wondering why
Is this your true legal name, sir? Spelled correctly?
I'm wondering why the judge is refusing to give me responsive answers to my questions when
At this time,
he
Mr.
said I should do it
Estabrook?
earlier.
Mr. Estabrook, is this your true legal name spelled correctly? You can be held in contempt of court and taken into custody. We'll try and keep you out. Is this your true legal name spelled correctly?
So, are you forcing me to accept this attorney?
I'm not your attorney. I'm just the attorney standing in for arraignments at this time.
Okay. So I would like to make it a matter of record that at this point I am under duress.
Okay.
Yes.
Okay, and is that your correct date of birth, sir? 7282.
I believe it is.
Okay. So you've been in here, you've heard what the arraignment process would have been doing, which is reserving all of your rights that have been read into the record and all of that. Okay? So that's what I was going to do at this
How
time.
come my rights aren't being honored right now?
Your rights are being honored.
They're not.
You'll talk to an attorney.
Why are my rights not being honored right now?
This is a copy of your next court date. They would like you to sign here, acknowledgement that you've received that next court date.
Why
He
are
does
they
sound
able to proceed
I mean-
against me without evidence of jurisdiction?
Never mind his voice where he does sound like he's 14. I'm sure he's an adult. But the way he talks sounds like a fucking teenager.
Allegation of jurisdiction, the evidence you can challenge down the road. This is not an evidentiary hearing. This is just an arraignment.
So you're saying that you have
We
the
do
right
not
to
have
drag me into court?
evidentiary hearing at this time.
You have the right to drag me
I
here
don't have
without
the right
evidence
to
of
ever
jurisdiction?
drag you into court. I'm a defense attorney.
Yeah,
We'll acknowledge receipt of 2 copies of the charging instrument. Proceed as truly named, correct date of birth.
I know he's
The
older
waiver,
than me.
relief, and advice of
That's
rights.
what's weird.
Reserve all rights read into the record.
What,
in
like Ben
JC
Shapiro?
384.
Oh,
Enter
you
a
know
plea
what?
of
You're
not
right. He
guilty.
does sound like Ben Shapiro.
I do not understand this at all. I do not understand what she's saying. I object to the plea of not guilty as well.
And Your Honor, will request the court date. I see the court is giving a date of March 16th, and I believe Mr. Estabrook has made it quite plain on the record that he does wish to represent himself, that he wants more of an evidentiary hearing at this time. Just want to make sure that that's been clear on the record. I think Mr. Estabrook has made that record.
I
but
object to that statement. I would say that I am concerned about evidence regarding jurisdiction. However, I'm not concerned about evidence that would be standardly used at an evidentiary hearing. I am only concerned with evidence of jurisdiction at this time.
If we give you the number of the lawyer, you can ask her any of the questions that you've raised.
I move to dismiss the case if the prosecutor has not submitted evidence of jurisdiction.
That's not how that works.
We'll go on that in the future.
You will not move at this point?
No.
What is being right?
What are your
Tell the
grounds?
lawyer, if you want to raise these issues, the lawyer can help you raise them.
What are your grounds for dismissal?
Because I'm wearing a black robe and you're not.
Mr. Estabrook, will you please sign here acknowledging your next court date.
You wish me to sign this under duress?
Yes.
So you can take your juris my diction crap, cram it up your ass. I was not expecting Matrix quotes on tonight's stream, but here we are.
May I have the evidence that the prosecutor does have at this point?
Your attorney will have a copy of the discovery. You can get a copy from your attorney.
I'm not allowed to have discovery at this moment.
No, not this moment. We do not have a copy of it at this time for you.
So what are you saying that I need to do in order to
Contact
not be
your
thrown in
attorney.
jail? I need to call the fifth person?
And make your court dates. If you want a copy of your of the police report and you can get that from your attorney. Call them and make your court dates. Your next court date's March 16th at 9 a.m. back here.
I thought this was the United States.
Oh, did he just do the I thought this was America? He just did the I thought this was America.
I thought this was the United States.
He did! Oh, I'm sorry, this is America. I'm sorry, this is America. All right. This is the one I think y'all are talking about where he's like trolling the officers at a random stop. I'm trying to find his updated court appearances. What the fuck? Hey, what's up, James? Give us a Herbert or Mickey Mouse before the end of the stream? Oh, come on! Don't do that to me. Okay, I think I need to find somebody else who uploaded it, though. Here we go.
I simply want evidence establishing jurisdiction.
So again, I'm not going to be accepting a plea until you're willing to give up all your rights.
But if the state does not present evidence, it never presents evidence prior to the not. It's never.
We going?
Mr. Estabrook?
Yes, ma'am.
You can come on up. I need to go up to that microphone there.
Okay. Is Jenna Plant here?
She's not. Mr. Maswell standing in for her. Is she dealing specifically with this claim?
Yeah, I actually have a motion.
Okay.
I filed it.
There we go.
Who's Mr. Maswell?
He is, he's the person who's in charge of the, first deputy under this claim.
By the way, to answer your question, the Bach is actually pretty good. I still prefer Shiner, but this ain't bad either. To answer your question, Jeremy.
Person who's in charge of the administration of all of the misdemeanor cases. For the state.
So I have what I believe called a motion to dismiss.
There's something, so I have a note here from Judge Roberts on July 15th that you withdrew your waiver of counsel.
I did notice that she had written on this document that quoted the defendant rescinded his previous waiver of counsel, but I wanted to do that is one thing I wanted to correct the record about because I have never authorized a waiver of counsel in the first place, so I'm not sure how I could have rescinded it.
Well, if you, so you never. Did you want to appear on your own behalf, or did you want an attorney?
I'm still trying to make that determination. I need to be informed that a cause of administrative proceedings have not yet been arraigned.
Okay, well today is going to be the day.
Okay, well, hold
on a second. Today is going to be, you haven't been arraigned?
No, I have not, and I've made that clear on the record.
Well, that's a lie, because he was arraigned, but he's lying to the judge here.
And I've also made it clear that what the record says is in error when it says that I have been arraigned. So I still have a clarification.
I'm going to take judicial notice that you've been arraigned if that's what the record reflects.
Objection, one clarification. How can you say that I've been arraigned when I've not been informed of the cause of nature of the proceedings?
Taking judicial notice of the record. Let me see what the record reflects.
Is it not?
Record reflects that an arraignment did occur, so I am finding that an arraignment did occur.
Objection, point of clarification.
Yeah, I'm sorry about that, man. YouTube's gonna YouTube.
I'm saying that a knowing or voluntary plea was entered on your behalf. A plea of non-guilty was entered on your behalf. You can later withdraw or change that plea, but that's I'm finding. I'll write a minute order after that.
I would object to that because I have made it very clear that my intention is to enter a guilty plea.
Okay, you can change your plea to guilty plea at a different time.
Am I allowed to make a plea in the first place?
So let's talk about, the arraignment occurs, we're past that. Let's talk about
objection. I have not.
I want your objection for the record.
I have not entered a non-voluntary plea at this time.
I'll let your objection for the record. Let's talk about you can be quite long. Let's talk about your decision to have an attorney or not. Today's the day.
Well, I will make that decision as soon as I've been arraigned and asking has the prosecutor submitted any evidence that the court has jurisdiction to impose upon me. That is the clarification.
The court has found, based on the arraignment that has occurred, that there's jurisdiction. You need to make a decision right now.
Objection.
Listen to me. I'm going to hold you to contempt. If you don't decide by 11 o'clock today, whether you want to proceed as your own attorney or whether you want to have an attorney. I'm give you a direct order that you need to make that decision in the next 15 minutes.
Well,
If you fail to comply with my order to make that decision in the next 15 minutes, to either proceed pro se or you get an attorney appointed to represent you, then you're subject to being held in contempt of court and going into custody.
are you declining me the opportunity to be arraigned and be informed of the possible nature of this proceeding?
Hey, Tom. Hey, Tom, thank you very much for the $5 super chat. I like when the judge told Jeremy to half-wit to shut up his pie hole. Everybody... Oh, Jeremy DeWitt in court? I have not seen that, and I would love to see that.
Can you tell me how you found that? What actual evidence?
I'm taking additional notice.
Do you have factual evidence that I have been arraigned?
I'm taking additional notice of the record that the court reflects that you were arraigned.
So you are relying upon opinions that I have been arraigned?
Yeah, I'm just observing. So I'm just observing. So what are you doing?
Court's going to be recess for 15 minutes. And then that time will be for waiver of counsel.
Yes, I do not wish to either make a decision.
I'm ordering that you make a decision by 11 o'clock today.
And what
we're going to go off the record. You're going to give me a document for waiver of counsel.
Under what authority are you ordering?
Would you never do it? If we don't do it, then I'm going to call the deputies to you.
Has the prosecutor submitted evidence in jurisdiction and imposed upon you? And you let me know what that evidence is.
You can sit down and read that document.
I will not be able to make a decision unless I get an answer to this. Also, I have a motion to dismiss.
I'm giving you an answer to it. You can file your motion to dismiss after we discuss your issue with the attorney.
I have filed a motion to dismiss.
Okay,
and
I can discuss it.
I cannot make a decision about an attorney until...
We'll discuss it at that time. No, you need to make that decision.
So you're forcing me under duress?
We're not on the record to show that it's under duress and it's not under duress.
It is under duress.
Damn it, why is my command not working?
Mr. Estabrook, hi, I was just getting a little update on what was going on with the case. Talk through it.
There we go. Now we're going.
So, did you hear that I'm being coerced and threatened with violence if I don't either make a decision to have an attorney or waive the attorney?
So yeah,
I did not hear that, but what I heard was you guys want to go back and
So she is saying that because of that decision, that I will be home, and that she has stated on the record that I'm threat of violence. So what I have here is a new copy is what I believe you call a motion to dismiss. That states in there the evidence of why I have not been arraigned and why this case should be dismissed. However, I still have
Okay, I can barely hear what the hell they're talking about. Hold on.
kind of played the whole like.
You have the right to hire your own attorney. The public defender agencies from which we draw on the court-appointed attorney are not affiliated with the state. They're independent nonprofits. They are. There is a system called the Oregon Public Defense Services Commission, which is signed by statute to manage various affairs of court-appointed attorneys, but the attorneys themselves are not employed under that system. They're employed as either their own independent attorneys or under the non-profit independent nonprofit.
But are they not licensed by the plaintiff?
They're not licensed by the state bar, Oregon State Bar, which is a
Okay, now I know where we're at. Here's another tactic that Mark Stevens likes to do. And that is, they like to post this idea that because attorneys are licensed by the state, they inherently work for the state. And because the judge's salary is paid by the state, they are invariably in cahoots with the prosecution. Therefore, there is a conflict of interest at play. But we all know that that's not how that works. The judiciary and the executive are, at the very least on paper, supposed to be separate branches of the government. Therefore, there is no conflict of interest at play. The same is that an attorney, the fact that I'm licensed by the state does not mean I am beholden to the prosecution or I adhere to the state. So that's not how that works either. But again, according to these ass clowns' ideology, they don't think that they're subject to any laws of the state of Oregon. Therefore, they consider themselves wholly separate from anything associating itself with the state of Oregon. And therefore, there's a conflict of interest regardless of how you and I understand a conflict of interest to work.
Non-profit. So they're not licensed by the state of Oregon?
They're not, their authority comes from the statutes of the state of Oregon, but they are not directly licensed by the state in the sense that it's the plaintiff through the district attorney's office. They have nothing to do with the district attorney's office and the attorney general's office, and the governor have nothing to do with licensing.
Well, it seems you're differentiating between the prosecutor representing the state of Oregon and the state of Oregon, which licenses all of the attorneys in this.
Well, as I've explained to you, sort of the different avenues of authority. The authority for government comes from statute of the Constitution. So, the state controls multiple aspects of our lives. So there's no escaping that.
All I've been attempting to do is ask for evidence that the Constitution and the statutes that I've used to apply, and I have not seen any factual evidence of that. However, since you are threatening me with by saying that I'll go into a cage if I don't make a decision, I will submit this way to the counsel. I'll review it with you as I'm obligated to do so by law. And how would you like me to answer the question? I'd like you to answer how you would like to answer. Okay, so am I being threatened with contempt if I answer honestly? No, but I will let the decision that I ordered you to make was to either appear on your behalf or wait our have a court appointed attorney for the day. I actually failed to advise you of the third option that you have, which is that you can have an attorney serve as your legal advisor if you would like the assistance of an attorney, but you would still have to sign this document representing yourself as your primary attorney. Well, what I would like to have is assistance of counsel that is not licensed by state of Oregon. I've explained to you that assistance of counsel is not licensed by the state of Oregon. So you're failing that you disagree with my statement of what that is. Is that correct? Well, do I have the right to assistance of counsel of my choosing?
You have the right to the assistance of counsel of your choosing so long as they are licensed by the state of Oregon. There it is. Period. End of story.
If you, not for the court, you would not pay for that.
Well, I'm not asking you to pay for it. I'm simply asking if I have the right to choose anybody that I want as assistance.
If they are a licensed attorney with an Oregon State bar number, they may serve as your counsel, whoever that may be.
So it sounds to me as though I'd be applying the right to assistance of counsel that is not licensed by the plaintiff.
I don't. No, I disagree with that.
And that is your opinion?
Yes. So I reviewed, I handed to you this document called Waiver of Counsel, and I see that you reviewed it and an initial called for your initials and that you signed it. Did you understand everything in this paperwork? I'm not asking you to agree with it, but did you understand it?
Well, you indicated that I signed it.
Right, so but I'm just checking to make sure that you understood what you read. Some people don't read things, they just sign things.
So, with all due respect, I don't want to go to jail today, but I do want to point out that I didn't know that I had the time to read through it very clearly. I haven't, however, read the form, which I believe is very similar, if not identical to that form in the past.
Okay.
So I'm able to comprehend what I read, yes.
Okay, and are you, there's nothing to indicate to me that you are in any mental infirmity today, so I believe you to be competent to make this decision. I have an obligation to let you know what you're charged with, and so what you are charged with is count 1, interfering with a peace, parole, or probation officer, which alleges that on or about February 28, 2016, in the state of Oregon, that Robert Earl Estabrook did unlawfully and intentionally refuse to obey a lawful order by a person known by the be a peace officer, contrary to Oregon law. And count 2, charge of criminal trespass in the second degree, which alleges that on or about February 28, 2016, in the county of Multnomah, state of Oregon, that Robert Estabrook did unlawfully and intentionally, knowingly, or recklessly remain in and upon the premises located at Portland International Airport screening area, contrary to state law. The first count 1, interfering with a peace officer, is a Class A misdemeanor. It carries a maximum sentence of 1 year in jail and $6,250 in fine.
Objection. Point of clarification. Can you please explain to me what you mean by $6,250?
No recording. No recording. No recording.
I'm not.
Okay.
You are, asshole. But okay.
Well, no recording yourself on.
All right.
And then count 2, criminal trespass in the second degree, is a Class C misdemeanor that carries a maximum sentence of 30 days in jail and $2,500 in fines.
A point of clarification, can you please clarify for me what you mean by those numbers in the fines?
Now you know. This is where it stops being a question, and now it's, you know, that this guy is being an ass clown and being intentionally obtuse, because now he's questioning, what does a fine mean? What do these numbers mean? Like, he's literally asking her what a fine means or what a fine is.
Yeah.
Hey, James Butler with a £2 super chat. Thoughts on the I don't stand under tactic? It's asinine. It's based on a complete misconstruing of the word understand, which you, me, and every English-speaking person on this planet knows what it means. It means, do you comprehend what I'm saying? It does not mean I accept whatever it is that you're telling me. Nobody says that. It just simply says I am capable of comprehending the words that you just spoke to me. But these guys are fucking idiots, and so they think that it has more significance than it does, and therefore I don't stand under that statement, as if it's supposed to be like an avoidance tactic that they can employ. It's so stupid. It's one of the stupidest things I've heard throughout this entire sovereign citizen endeavor. The whole stand under, understand bit.
Well, that's the absolute maximum jail time that you could ever get on those charges.
Right, I'm not asking specifically about the jail time.
That's the maximum fine. So the maximum fine that any court could ever impose on you, I'm not saying this is what will happen, it's just the maximum allowed by law.
But I mean, what do you mean by the court imposing a fine?
If you were convicted, the court would have authority to impose a fine. The most expensive fine the court could impose would be $6,250 on count 1 and $1,000 on count 2.
Point of clarification, can you please explain to me what you mean by $6,250 and $1,000 fines?
$6,250 is the amount of the fine.
Hey, BL with a $10 super chat. Drink a beer for me, please. I've been sober for 5 years and kind of miss those craft beers. Keep up the great work. Well, I appreciate that, BL. I mean, congrats on, being sober for 5 years. That's good to hear, man. But you know what? I'll imbibe in your name. How about that? But thank you, man, for all your support.
So
Do you not understand that number?
Salute.
It's not the number that I do not understand. I don't understand what that means and what you were asking for specifically.
It means $6,250. And it can only be imposed if you were found guilty.
And how are you expecting me to
Hey, John, I'm glad to hear that too.
And what it is that I'm supposed to be giving you?
I'm not going to answer that question.
Okay, she's now at the point where, I am seriously not going to answer the question anymore because I cannot possibly dumb it down for you any further than that. Seriously. Now, she has to be aware that he's being, intentionally, obtuse.
So you're not going to clarify this for me? Because I'm wondering what you're asking for. You're asking $1,000. So you're not going to let me be informed and answer relevant clarifications?
That is a maximum penalty that you face.
Unless for the record that the judge is non-responsive and she is not informing me of the these proceedings.
I know that you have been in communication with Ms. Plank, and that you guys have discussed discovery. Is that accurate?
I think Ms. Brenda Allen discussed discovery. I have discussed the plea offer that's been extended in this case that was justified.
But I'm wondering, can we hold the prosecutor to her burden of proof that?
By the way, as spoiler alert for those wondering, and Gary, thank you for giving me the citation. Ultimately, one of his 2 charges was overturned. He was charged with 1 count of interfering with a peace officer and 1 count of second-degree criminal trespass. They acquitted the court overturned his conviction on interfering with a police officer because ultimately it was passive resistance, and in Oregon state law and precedent, passive resistance does not cannot be construed as interfering with a peace officer under Oregon state law. So therefore, and however, the decisions that established that was after he was charged with these crimes, but nonetheless, the court said that he should have been acquitted of that 1 charge. However, he was still affirmed on his other his other conviction for second-degree trespass.
See if she has submitted any evidence establishing jurisdiction for the court to impose upon you?
Well, they have an obligation under law to give you discovery. Have you received discovery of the case?
I believe that I received some paperwork from the alleged prosecutor, and I have not yet found any factual evidence establishing jurisdiction, so I'm wondering if there is any that is being held from me, or if you're aware of any evidence.
I don't have access to their court files, or their files that they use when they prosecute. You can file a motion to compel discovery. You would have that right to do so, and we would schedule a hearing on that motion to compel discovery if you chose to do that.
Have you read the motion that I have submitted?
I've not yet, because I need to clarify. I can't communicate with you if you're represented by a lawyer. I have to communicate with a lawyer. So I need to clarify whether you were representing yourself or a lawyer. So having indicated that you understood everything that you reviewed, even though you don't agree with it, and the court finding that I have explained the elements of the crime and the maximum penalties, finding that you know
explain to me what a X dollar fine actually means. So I I'm not sure what yours is.
Not finding that to be a plausible question.
Well, I'm simply asking what you would be.
Yeah, the judge is like, he's asking again what a fine is, and she's like, I am not even going to entertain that at this point.
Fine actually means.
Yeah, he's asking what a fine is after she had already explained to him about 5 minutes ago what a fine was.
So I'm not sure what yours is.
Not finding that to be a plausible question.
And she says, I find that to be an implausible question.
I'm simply asking what you would be asking for me if you impose a fine upon me. I'm wondering about that.
I'm pretty confident, Mr. Estabrook, that you understand the concept of a court penalty.
And she says, I'm pretty sure you understand the concept of a court penalty.
And dollars, I'm pretty sure you understand.
And dollars.
My point of clarification, I'm asking for a relevant clarification on the record of what you are trying to impose when you are...
We're not trying to impose anything right now, I'm just letting you know the court could impose.
But you're not clarifying what that means. I have no idea what you mean by $1,000 fine, for example. I have no idea what you're asking for in that matter.
I'm not asking for any fine, but I'm letting you know that the court, if you were found guilty, with all the rights that you have at trial, right? So you have the right at trial to have a jury listen to the evidence. There would be 6 of 6 people. You have the right to have the district attorney bring all the witnesses to trial to prove your guilt beyond a reasonable doubt. You have a right to have that process occur. The state would be obligated to call witnesses and examine those witnesses, and they'd be under oath. And
impossible would mean what in layman's terms? I think what she's trying to say is like, I have already given you an explanation of what a fine is. I've already given, and I am not going to sit here. She's basically acting like acting as any layman, any reasonable person. This guy standing up right here. Implausible meaning there is no way that you, as a grown adult who is capable of speech and comprehension at this point in juncture, would not know what a dollar is, what a fine is, and what a court penalty is. That's what she's saying. That it is implausible to me that you do not know what these concepts are at this juncture. And that's why she's not going to entertain it. Entertain his playing dumb. It's all about the totality of the circumstances. I think that's why I like Arty's and the mental health. Some of these are, well, BL, there are a handful of sovereign citizens that I've seen, or sovereign citizen videos that I've seen, where I'm like, okay, this person, it's more than just this person believes in stupid shit. It's that this person is actually mentally unwell and was caught up by some guru who fed him a bunch of BS.
Your testimony would be introduced into the record. You have the right to cross-examine those witnesses. You have the right to call witnesses of your own. You have the right to compulsory process under the Constitution, so you have the right to issue a subpoena to get witnesses to appear in court in your case on your behalf.
Do I have the right to prepare me for hearing today?
Well, I'm letting you know right now. You've asked me, I'm attempting to explain to you the question that you asked about the fines, and attempting to explain to you the process and how that works. And so after all of that process, after closing arguments, the evidence would be submitted.
Oh, but this guy's not one of them. No, I know this guy knows exactly what he's doing. I firmly believe he knows damn well what he's doing. He knows damn well what a fine is. He knows damn well what a court penalty is. He knows damn well what dollar means. He is not one of those folks.
Jury for their consideration. If the jury found you guilty after deliberations, then the court would come time for sentencing. So that would come time for the judge to say, what penalty should I impose now that you've been found guilty? The worst thing that the judge could ever do would be, as I indicated, up to 1 year in jail on the Class A misdemeanor, 30 days on the Class C. And then the worst thing that the judge could do is $6,250 in fines. And then you would be obligated to pay those fines.
Can you please explain to me how it is that I can, quote, pay those fines? Because I'm not sure what you're asking specifically.
Okay, so I don't know how you can pay those fines because I don't know anything about your own personal circumstances. Financially, you would have the right to present those to the judge at the time of sentencing and have the judge take those into consideration. So I have accepted your waiver of counsel.
Basically.
On clarification,
Kinda.
So I'm asking if I were imposed with $1,000 fine, what is it specifically that the court is going to want at that time?
We're not there yet. You said you had a motion that you wanted.
Well, I'm attempting to be informed of the cause of nature of these accusations, and you're indicating these as.
I've explained it sufficiently.
But by objection.
And I'm finding that you're being obstinate, and I'm.
See, she's already calls him out on it. She already called him out on you're being obstinate at this point.
Are you saying that me asking for relevant clarifications is being obstinate?
I've explained it 4 or 5 times, and I'm confident that you understand the concept of what I'm talking about.
So you're assuming that I understand what a fine is?
Yeah.
As I understand it.
And how is it that you're able to prove
I'm not going to answer that question. You have a motion that you wanted to file?
Yeah, I would move that you recuse yourself.
I'm not going to grant that motion, and I'll sign a minute.
On what grounds?
As to that?
On what grounds are you declining that motion? I have a relevant reason why you should.
What is the reason why?
And now he tries to say, I moved to recuse yourself because she's like, I'm not going to buy into your BS and thinking that you don't know what a fine is. Now he's going to say, I moved to recuse yourself? Really? This is why this Robbie pisses me off more than anything else. Because we all know what he's doing. We all know that he's playing a game.
I feel I should recuse myself.
The reason you should recuse yourself is because you have shown bias. You already threatened me on record with contempt if I did not make a decision. You are forcing me to make a decision when all my only intention is to.
Hey, what's up, Celine? Long time no see, man. Nope, this is Robbie Estabrook.
You are free to do so, but I cannot take a guilty plea from someone who has either not agreed to represent himself or have an attorney represent him.
Well, I'm simply asking before I make that decision, has the prosecutor submitted any evidence that the court has jurisdiction to impose upon? And you are not holding her to her burden of proof.
Well, right now we're not having a trial. Right now we're having an administrative hearing to determine what is the next step in your case.
I'm not asking for a trial. I'm challenging jurisdiction at this time. So I've asked, has the prosecutor submitted any evidence that the court has jurisdiction to impose upon? And you are not answering.
Well, all the information I have is that you've been arraigned and that you've had an opportunity to have discovery or information in the court system that's sufficient for me to have authority to proceed as the judge in your case. How is the plaintiff? Do you want to respond to that?
So, Your Honor, at the last hearing, Judge Roberts, I believe, informed Mr. Estabrook that the only way in which he can challenge or require the state prosecutor's office to prove jurisdiction, a subject matter or personal, is to, in fact, request a trial. You cannot have it both ways. You cannot require the state to prove jurisdiction and then also, which is introductively, the only way in which you can require the state to prove up any element, including jurisdiction.
Because what the prosecutor's saying right here is that he cannot have this right now. But I feel like the problem that the prosecutor's doing here is that she's not stating straight up that a prima facie case has already been made that demonstrates jurisdiction. But if he wants the prosecution to prove jurisdiction, as what he claims, there has to be a motion. And actually, there has to be a pretrial motion or at trial. So, in that respect, he wants to have his cake and eat it too. He wants to have that jurisdictional hearing before a trial happens. That's not how it works. But they don't say it straight up that a prima facie case has been made or been established that jurisdiction is there. It's up to him now to make that formal challenge, and then it's up to the prosecution at trial to prove jurisdiction by having the officer say, I saw this guy, trespass at the airport on this and such and such day.
It's a request to trial. And I will state for the record that the defense attorney told me that I could request a trial, or I'm sorry, not a trial, but a hearing for the prosecutor to prove jurisdiction before the trial happens. And I went to the clerk's counter to ask and request such a hearing, and they said that I needed to bring it up to you. Right. So I'm requesting a hearing for the prosecutor to submit evidence establishing jurisdiction before the court continues to proceed in this matter.
Well, normally the way we handle motions is to send them. We have, and this is a court rule, local court rule, is that we have the motion hearings prior to trial. Unless it's a discovery matter, as I indicated, we felt like we didn't have discovery, we would schedule an early motion to compel discovery.
Well, so far I have clearly not received any factual evidence establishing jurisdiction.
If you want to file a motion to compel discovery, then we could have that hearing ahead of time to make sure that you have all of the discovery that the state is able to turn over.
Well, can we ask the prosecutor if she has turned over all discovery at this time?
I can tell you, however, I have personally not discovered any matters, but I can tell you that there are notes in the file that indicate that on 6/6, T.A. Allen gave to Mr. Estabrook in person, and on 6/7, matters again emailed to Mr. Estabrook, and the notes on every CD indicated they were given to Mr. Estabrook. So I can certainly re-photocopy all of the reports and mail them to Mr. Estabrook, but it appears as though all discovery has been disclosed to Mr. Estabrook.
Okay, so if all discovery has been disclosed to me, then the evidence of jurisdiction is still lacking. And so I will move to dismiss the case since there is no evidence of jurisdiction.
I'm going to deny that motion at this time.
On what grounds?
The court finds that I do have jurisdiction to conduct hearings in this matter.
And how is it that you're able to find that?
As I've indicated, there's been an arraignment. The laws that allow me to have jurisdiction over your case.
Objection. Can you explain to me how it is that I have been arraigned?
You may renew your motion at the time of trial. So I'm denying it right now. But you may renew your motion at the time of trial.
I do not wish to go to trial. I am attempting to enter a guilty plea. That is my...
Again, another bullshit tactic. I have a signed plea of guilty, Your Honor. I just have some clarifications. Bullshit. Number one, it's a fucking piece of paper with a signed I plead guilty, which isn't how plea agreements work. There are actual forms involved where if you want to plead guilty or plead no contendere, no contest. I try to be smart because in Texas they say no lo contende, contendere. I'm speaking Spanish, but I know it's Latin. But shut up, leave me alone. I'm kind of inebriated. But yeah, there are actual forms to fill out for that. So just having some signed affidavit or signed paper saying I plead guilty is like nothing to a judge.
Do you want to do that now?
Well,
Was we're on the debate with more on Virgo's channel with Liz D. I don't think so, BBQ.
I'm asking, has the prosecutor submitted any evidence that the court has jurisdiction to impose upon?
We've had this discussion.
Just say yes or no from the prosecutor, please.
And Your Honor, this was sort of the same colloquy we engaged in front of Judge Roberts at the far right of this hearing. Mr. Estabrook expressed an intention to accept the state's plea offer. I don't know if he's either not understanding or choosing to not acknowledge my representation that he certainly can accept the state's plea offer, but
I'll have to take a look at it.
doing so, he cannot challenge any of the elements of the offense, which includes proving jurisdiction, subject matter, or personal. So if you wish to challenge any element of the offense, both subject matter or jurisdictional, you cannot mistake the plea offer is not extended.
Are you telling
There
me?
is no option C. Option A is you accept the state's plea offer. Option B is you challenge any element of the offense to include jurisdictional matters. If you choose option B, that means we have a trial. There is no option C.
Well, I'm not.
Exactly. Okay, this is important, what the judge just said. If you are trying to challenge jurisdiction, that means you have to go through the arraignment process first. You can't just stop here. You want to challenge the elements of the offense, you have to go through a trial. You can't do it here and now.
Are you?
So you cannot challenge any of the elements of the offense, which includes proving
Yes.
jurisdiction, subject matter, or person.
So
If you wish to challenge any element of the offense, both subject
If you wish to challenge any element of the offense,
matter or jurisdictional, you cannot mistake the plea offer is not extended.
are you telling
There
me?
is no option C.
there is no option C. Either you plead guilty, which means that you are ultimately accepting jurisdiction in the first place, or option B, you don't plead guilty, challenge jurisdiction, and we go to a motions hearing to make that determination.
A is you accept the state's plea offer. Option B is you challenge any element of the offense to include jurisdictional matters. If you choose option B, that means we have a trial. There is no option C.
Well, I'm just wondering how it is that you're able to compel me to come here under threat of violence if there is no evidence of jurisdiction at this time. I've already challenged the record that states that I have been arraigned because I know for a fact that I have not been arraigned, and I've made that
You have been arraigned, you lying sack of shit.
repeatedly clear on the record.
I have just created a record that you have made a motion to dismiss for lack of jurisdiction, that I've denied your motion to dismiss for lack of jurisdiction. The way to protect your rights on appeal would be to have a trial, because what happens when you enter a plea, and mind you, I can't give you legal advice, because you have to recommend your own attorney.
Objection, I'm not an attorney.
Well, I have found that to be the case.
And again, you're relying on legal opinions and not facts and evidence.
I rely on my own mind.
Your own legal opinions, yes.
Um,
I would clarify for the record that this, Ms. Albrecht is relying on only opinions and not factual.
Also, he's also being disrespectful to the judge by calling her Miss Albrecht instead of Judge Albrecht. This is also another thing that they like to do. Decorum would be Your Honor, and not even Judge Albrecht. It would be Your Honor. But he refers to her as Ms. Albrecht. But, yeah.
Matters at all, and she is claiming and assuming that I have been arraigned, even though I've indicated repeatedly that I have not been arraigned, and she refuses to give grounds as to how it is she has found that I am arraigned, except to rely on the opinion. Because
I've made those findings on the record.
you have not made findings of fact.
Do you want a trial?
Of course not. My intention is to enter a guilty plea. I simply want to know how this court has jurisdiction to impose upon me at this time. What evidence has been submitted to establish that? Because you can't be forcing me to come here without evidence of jurisdiction.
We've had that conversation, and you made your objection and noted for the record. The way to protect your objection and protect your legal rights going forward is to have a trial. I can give you a trial date.
Is it your intention to continue to violate my rights?
I'm not going to accept your plea. When you enter a plea, a judge has to be willing to accept your plea. And when you enter a plea of guilty, you give up a lot of very important rights. One of the very important rights that you give up when you enter a plea is the right to appeal legal rulings that a court makes. I don't think you want to give up your right to appeal my ruling because you object to my ruling. So, if you want to enter a plea, we could discuss that today. But if you're going to continue to object to jurisdiction, then I'll need to set a trial date for it.
I simply, all I want is a yes or no answer from the prosecutor. Has she submitted evidence establishing jurisdiction for this court to impose upon me? Yes.
And the answer is the charging instrument.
Answer that question.
Are you answering?
When is the state ready for trial?
Objection.
Trial dates are September 1st or September 6th. Those dates still work.
They don't work for me.
That date is pretty crowded, but I think Mr. Alcon verified earlier today that it's actually not as crowded as I perceived it. So
Thank you guys again. I see 87 folks watching this evening. Thank you very much for your love and support. I really appreciate it.
However, that is much too soon because if I were compelled to have a trial, so I want to state this for the record, if I am compelled to have a trial, then of course I would intend to call witnesses and prepare for cross-examination, and I would need to subpoena witnesses, and I would need to have time to do all of that. But before I can do any of that, I need to know, has the prosecutor submitted any evidence that the court has jurisdiction to impose upon me?
you
Yes.
need to record sufficiently. So how long do you need to do the subpoena until you're prepare for your case?
May I get a yes or no?
At this point, they're not even entertaining his constant questions again about jurisdiction. They're like, we're moving on for a trial date. Do you need more time to get a subpoena for witnesses? Like, because again, she's not going to constantly answer the same question over and over and over again. It's obnoxious and it's irritating, and it's designed to be that way. It's designed to get underneath the judge's skin.
Answer to
Let
that.
me answer that question. I'm not going to answer that question.
Well, I actually haven't. I'm asking on the record, may I receive an
Your opinion that I haven't answered it, I've answered it and say I'll respond to your inquiry.
Objection. She's not said yes or no.
When is the court date? When do you want the court date?
I don't
September
want-
1st, that's not work for you. When would work for you?
I don't want to be forced to come back any longer. I am a very busy person. I am
Oh, I bet you are. I'm a very busy person. Oh, yeah.
very involved
You're a very busy person to fucking waste the court's time like this, isn't it?
in the community, and I have
Oh, you're a very upstanding member of the community?
a lot of things on my plate, and I don't have time to be violated, have my rights be violated by people calling themselves judges and juries.
When would you like your case to be heard?
I am not submitting to the court's jurisdiction. I have not been arraigned.
On what your objections, when would you like the case to be heard?
I want to be heard right now. I would like to be able to enter the plea that I'm attempting to enter.
A plea has been already entered for you, which is not guilty because you refuse to enter a knowing and willful guilty plea. You've already stated as much. The fact that you are challenging jurisdiction means you are willing to come back to challenge said jurisdiction. They're not going to do it today. Sorry, it's not how it works.
I simply want evidence establishing jurisdiction.
I appreciate that, Deacon.
Establishing
You don't gotta do anything, really. You've already been being here and watching me is more than enough support. It really is. Thank you.
I've answered the question, so may I just get a quick yes or no to the clarification on the table? Has the prosecutor submitted any evidence that the court has jurisdiction to?
And again, this is the statement from Mr. Estabrook, but also to be put in the record. The state only presents evidence when there's a trial. That is when the state presents evidence.
See, this is where the prosecutor was wrong. Here's where the prosecutor is incorrect. The idea is that they provided prima facie evidence of jurisdiction through the charging instrument. They only need to provide additional supporting evidence at trial. That's what she should have said.
It does not present evidence. It never presents evidence.
But she's also correct in the sense that they don't provide this. They don't provide such additional evidence at this point in at the trial. This is an arraignment. They don't, or even it's not even an arraignment. It's a motions hearing, or it's like a pretrial conference. I think, if I recall correctly, he keeps on claiming that he was never arraigned, but he was. So this is like a pretrial conference. So we're not even at a motions hearing where the prosecution would provide said evidence. So no, at this juncture, they wouldn't be providing this evidence because the evidence is for the jury to weigh at trial or in a pretrial evidence or at an evidentiary hearing. So she's correct in that regard, but she should have clarified by saying that they're a prima facie jurisdiction has been established prima facie via the charging instrument.
Prior to the entry of a plea. So you are asking for option C, which does not exist. The state will never present evidence.
Probably. But I think no matter how passive aggressive or how quiet of a soft of a voice you're speaking, if people can gauge that you're intentionally being obstinate or obtuse or wasting everybody's time, anybody's going to get fucking annoyed at this point. I'm getting fucking annoyed, but I've heard this before.
Prior to the entry of a plea. You cannot have a plea.
Thank you guys very much for all of your support. I really do. Thank you.
Am I presumed innocent?
I'm gonna have one more and then one more beer and then I have to stop because again I have to wake up in the morning. All right, one second. I'm not going.
You're presumed innocent of everything.
Okay, so then how is it that you've already found that I'm guilty of jurisdiction at this time?
Well, jurisdiction is not an element. Jurisdiction is authority for me to engage in certain acts as a court. And I have found that I have authority to engage in those acts by virtue of by virtue of those Oregon state laws, the statutes, the Oregon state constitution, the supplementary local rules, the uniform trial court rules, all of those rules combined give me jurisdiction to proceed as an authority as a judge in this case.
Are you saying
you need to pick a trial date?
Are you saying that the element of jurisdiction is not an element in these allegations and charges?
You need to pick a trial date.
Is that it?
It's not an element. Jurisdiction is a prerequisite for proceeding, but it's not an element of the crimes that the state would have to.
Okay, and so
when do you want a trial date?
I don't want a trial date.
Well, I'm going to give you one.
Well, the next, if you're going to force me to have a hearing, then the next time I can come in here will be sometime in November. However,
why is that far out?
Because I'm busy.
And are you busy with that is interfering with your ability to proceed on this case?
I am informing the community in regards to judicial misconduct. So I'm having stage play, which is transcript from all of these hearings, which will be performed in front of live audiences so that they can know.
But you want me? Oh God. Oh, you want me to get the cats? Well, of course y'all want the cats. That's all y'all care about anyway. The judge said it. The jurisdiction is an element of the process, not of the crime. Before I go on, Katie's before I go. No. Fuck your pickle beer.
Sorry, the city of Portland.
I'll look forward to buying tickets and attending with that.
You will name it that. I would clarify that if you set a trial date, I will not be prepared on that date because I will not have yet had a hearing where the prosecutor has submitted evidence establishing jurisdiction, so I will not have the opportunity to subpoena witnesses.
I need to set a date sooner. I can set it after September, especially since we're just making this decision now. Maybe like about 6 weeks from now, like the end of September and October.
Yeah, how about if we set it for call on October 14th or October 17th? Oh, is that the conference?
Yes, exactly.
All right. Maybe call the 7th for the 10th. That will allow us to ask for a good 6 weeks.
Again, I will clarify that I will not have the opportunity to subpoena witnesses before then because we will not have yet had a hearing where the prosecutor has submitted evidence in jurisdiction, which jurisdiction is something that I'm challenging.
You can certainly have that motion and then you can hear it at the time of trial. So October, it'll be on call for October 7th.
So are you indicating that I will have an unfair advantage that the prosecutor will have an unfair advantage at a trial if I will not be able to be given the opportunity to subpoena witnesses.
You can subpoena witnesses. Nothing that we're doing today interferes with your ability to subpoena witnesses.
I won't know which witnesses I need to subpoena until there has been evidence establishing jurisdiction.
So the person that does my music?
Are
you sure, James?
On that, but you will have the ability to subpoena witnesses. Setting call date October 7th.
Objection to clarification. You're saying you understand my argument, however, you're still railroading me and saying that I do not get the chance to subpoena the witnesses where I would be most effective in a trial.
You can subpoena whatever witnesses that you follow the law that govern issuance of subpoenas and you can subpoena witnesses.
The thing is, James, I don't have the means of being able to send it to him because he kind of dropped off the radar. He responded to a comment on one of my older videos, so I at least know he's, alive. But I don't have any means of sending it to him. I don't have his contact information.
You have right to compulsory process.
May I subpoena, since you seem to be holding on to evidence of jurisdiction and you're not sharing it? May I subpoena you, since you seem to have evidence of the prosecutors is aware?
The only evidence I have is from the court record.
Okay, so you're relying on opinions rather than facts.
I'm relying on the court record.
Even though... So, are you declining?
Okay, so that's fine. Okay.
Are you declining?
What's the most annoying lawyer movie? I wouldn't say, I can't say movie. I can say I look at Law and Order very differently ever since I went to law school. And I was a big fan of Law and Order, beforehand. I barely remember Legally Blonde that I can't even make a determination about it. There was... I could tell you movies that I loved, like My Cousin Vinny. Let me see, what else was it? 12 Angry Men was a really good one. There was, I can't remember the damn name. There was a movie with Dennis Hopper. Fuck, what's the name of that movie? A Few Good Men was good. What was the movie with Dennis Hopper where he kills his wife and almost gets away with it? What the hell's the name of it? I can't remember the damn name. Fracture. I think that's what it was. Fracture. I think that's what it is. Fracture. A Time to Kill was good. But Fracture. I love that one. Fractured. Yes. I love that one because of the Anthony Hopkins. Oh my God. I can't believe I had them mixed up. Yes. Anthony Hopkins, not Dennis Hopper. I'm so sorry. Yes. Anthony Hopkins. I was thinking of Anthony Hopkins. I apologize. Fractured. Yes. Was Anthony Hopkins. That was fucking awesome. I love that one.
Finding my ability to do.
I've already noted that.
And I have noted that I have not been paid. So I'm going to settle this difference.
I love Devil's Advocate, but...
Any facts, or are you going to continue to use arbitrary?
I consider them to be facts, you consider them to be opinions.
And then I ask you, are you under duress?
Yes, sir.
I do not feel like
so you don't believe that you would
What, you want me to watch the Rick and Morty clip again?
be under duress if you might be afraid of losing your job if you were to entertain my arguments?
I've entertained your arguments, and I entertain her.
Are you familiar with the handbook that the judges read?
Ricky Martin, Ricky Ricardo. Oh my.
If there is a complaint that you would like to file with the Oregon Judicial Commission, you may do so.
Rainmaker. I haven't seen. Okay, I have to admit, I have not seen Rainmaker. I know of its infamy, but I have not seen Rainmaker. I've seen A Few Good Men, but I have not seen Rainmaker.
Record how it is that you are biased and you are in fact acting under duress at this time.
I don't agree that I'm acting under duress.
Oh, I mean, I can't believe I forgot about that. To Kill a Mockingbird, also a fantastic one. Justice for All, I've also seen that, was really good. But A Time to Kill, awesome. I like a lot of. I actually read a lot of Grisham's books. As far as books goes, The King of Torts by John Grisham and The Testament by John Grisham were both books I really enjoyed.
Are you familiar with the anti-government handbook that judges read?
Have a good night, James.
The anti-government handbook, I have not been provided any document called anti-government.
There is an anti-government movement handbook which was written in the 90s, which all judges have read and all judges use.
I've not seen Ironside, no.
As part of their training. And in that handbook, I would point to a page which notes how a judge lost her job, or lost his job, because he entertained certain arguments and made rulings with that person.
Parent the Wind. I'll have to make a note of these.
I'll let your statement for the record. If you wish to file a complaint with the Oregon Judicial Commission, you may do so. You can inquire through, I believe, there's a website that will allow you to get the information needed to file such a complaint. We're concluding this hearing.
Thank you, Honor. One more thing for the record. There's been some question about discovery. I will recopy everything and put it in the mail. I just want to confirm that it's mail actions.
Liar. Oh, okay. I do love Liar Liar. I did actually like that one. That was funny.
I did also want to ask, may I have the bar number of in this room, please?
You're not under any obligation to do that.
Well, they are all witnesses of a crime, and I would like to be able to call on the witnesses.
You need to be seated. You need to copy the paper.
So you're reviewing me?
You need to be seated. You need to copy the paper.
So you're not going to give me the bar numbers of the attorneys?
I'm not going to do that.
May I have your bar number?
Now he's asking for the judge's bar number because, again, he's going to try and threaten her by filing ethics complaints or some bullshit on her. Again, it's part of the whole shtick.
93190.
Thank you.
Stop breaking the law, asshole! Objection! On what grounds? It's devastating to my case. I laughed so hard because it's legit. It's true. The judge was done with this bullshit at that point. Overruled. Good call. Weight 105? Yeah, in your bra. Object. He's badgering the witness. It's his own witness. Well, in fairness, there is actual precedent for attorneys having to treat witnesses that they've called themselves as hostile witnesses. I mean, so that is actually a thing, but I digress. Fine. I mean, I'm gonna end up starting to quote so many movies at this point. You're right. I should need to do a live viewing of some of these movies with you guys on Discord, because at least on Discord, I'm not gonna get fucking copyright strike. It'll be something I have to plan ahead of time, and so that you guys will know ahead, so that we can watch. we absolutely should do some watch parties on Discord. I absolutely agree. I feel like the first one, no, Legally Blonde, no, not the first one. My Cousin Vinny is going to be the first one. Period. I think I would think that that would be like the film Devil's Advocate. No, not Alien or Aliens. Oh my god. My Cousin Vinny will be the first in my watch party. Oh, Jeremy, you merely redeemed yourself from pickle beer. I still haven't tried the Bloody Mary. I'll have to try it after I get back.
Real. The cases are real. Enter the court.
Again, this is they are quoting word for word a transcript of an actual court case.
Room of Judge Morty Durham Jr. The people are real. The cases are real. The rulings are final. This is his courtroom. This is Judge Morty. 60-year-old inmate Rick Allen is being accused of committing murder of a fellow inmate at Georgia Penitentiary. Mr. Allen claims that he is being set up and that his lawyer is requesting sexual favors in exchange for proper legal advice.
Okay, okay, Mr. Allen.
Right.
I believe that your case was going to trial not this Monday, but the following Monday. Do you understand that?
Yes,
Okay, I tell you, if you need to tell me something, I'll let you come up here to the podium so you can speak into the microphone and I can hear you.
Yes, the attorney here, I'm wanting to fire him.
Uh-huh.
And, I don't feel like he's doing any...
Who are you going to hire?
I'm not going to hire nobody. I'm going to try to get a different public defender.
There isn't... You have a right to an attorney.
This lawyer has...
You don't have a right to a specific attorney.
This lawyer has made sexual advances on me. He's misrepresenting my case. He told me if I wanted him to do a good job, I had to let him give me oral sex. He's had doctors at Central State Hospital put a false diagnosis on me.
Okay, I know Mr. Wyatt pretty well, and I don't think he has the ability to make doctors at Central State do anything.
Well, 69 people watching. Nice. Thank you very much. I appreciate that.
Did it, and he's the one that had me sit down there.
Thank you guys for all your support.
They may have done it, but I don't think that he had anything to do with it.
All right, well, he won't give me the discovery. There's things in discovery he's supposed to give me the incident and told me that it was the discovery.
Okay.
They're alternating documents that I've read.
If you want the indictment, I'll make sure you get a copy of the indictment.
No, I'm saying I got the indictment, but he's not complying with discovery.
Okay.
I'm supposed to get the autopsy report, the coroner report, pictures of the crime scene.
Coroner report?
Criminal background records. I want...
Is this a murder?
In the county jail.
Okay.
Yeah, I'm supposed to get the criminal background records, investigational summaries.
Mr. Wyatt, what discovery do you have?
I've given him everything I have.
You've given him everything you have?
Yes, sir.
He's given you everything.
This is a murder case, and This is a murder case, and you're telling me the only thing on discovery is a 4-page indictment?
I don't think he's saying that. I think he's saying he's given you everything he has.
He ain't given me no autopsy report. He ain't given me no coroner's report. He ain't given me...
Well, it may be that he doesn't have that. I don't know.
That's what I've been trying to get. He didn't give me pictures of the crime scene. I've seen other people go to trial on murder charges. I've seen what you're supposed to get. I'm not going to work with this attorney.
Well,
It's not gonna happen.
You've got.
I'm not going to trial with this attorney.
Well, you've got two choices. One, you can go to trial with them, or two, you can try the case yourself.
That airport messes this.
Think that's,
and I've got a right to have...
Wait a minute. Listen to me. That would be the biggest mistake you've ever made in your life.
So basically, you're sitting here telling me...
Now,
you're gonna find me guilty if I go to trial and try to defend myself?
You're probably right.
Again, this is the big mistake the judge made, and this alone should have warranted recusal, which, again, he eventually did recuse himself from the matter. But this alone, never mind what happens later, was grounds for recusal.
Right, that would be my guess if you try to defend yourself. You don't know anything about selecting a jury, do you?
No.
Do you know anything about cross-examining witnesses?
No.
Do you know anything about criminal procedure?
I know I don't have to let...
Do you know anything?
This guy suck my...
let me
To get some legal representation.
You know something? I'll be honest, Mr. Allen. I really don't believe that.
Well, I'm not concerned if you believe it or not.
But
I'm supposed to.
I'm actually very curious to know whether or not the numbers on his jumpsuit is his actual inmate ID. I would love it if it was, because that is some awesome attention to detail.
Supposed to have a right to an attorney, and I'm not going to work with this attorney.
Well, that's up to you.
So I hold myself in contempt if you try to pull me up here to court with that attorney.
That's fine. I mean, that's up to you. I told you what your choices are. You can go to trial.
I'm just telling you.
Listen to me.
I'll hold myself into contempt.
Listen to me.
You.
Listen to me.
Go yourself. I'm through here. Y'all done?
I'm finding you in contempt of court.
I don't care.
I know you don't, and I sentence you to 20 days for that. And if you say anything else, I'm gonna add 20 days for everything you say.
You.
40 days.
You again.
60.
Go yourself.
A year.
Your mama.
10 years.
Your mama.
You know something? This is gonna be an interesting trial.
Oh yeah?
Oh yeah.
You're not supposed to smile in court. You know that if you smile,
I can smile anytime I want.
it's a violation.
if you smile in court, that's a violation.
You're cussing and yelling at me?
I have not cussed.
Yeah, you did.
I am yelling.
Well, go yourself. Suck my
That's why I'm yelling.
Suck my
You know something? You are absolutely the rudest person I think I've ever met.
You reckon?
It's not his inmate number. That's disappointing.
If I let you suck my then I could get a fair trial here?
Oh, I don't think so.
I got a big now, and if I pull it out...
I don't think that's gonna get you a fair trial unless you have every one of the jurors do it.
I don't think that mouth is big enough, sir. I've got a big old donkey.
You know, I'm sure mine's not.
I've got a big old donkey for that ass.
Good. I'm sure the women love it.
I don't girls.
Oh no. I'm sorry.
I boys.
Oh, I'm sorry. You prefer men.
I boys.
You prefer men, right?
I white boys.
You white or black?
White boys.
Oh, butt boys?
With big butts.
Oh, of course. You know, you look like a queer.
Well, okay, so now you're calling me a queer in the courtroom?
I didn't call you one. I said you looked like one.
Your semantics for the win. I didn't call you one. I just said you looked like one. God damn it. Oh my God.
Yelling.
Do you understand the English language?
Wait, you're yelling, you're laughing.
Do you understand the English language?
This is kangaroo court, sir.
Do you know what? No, we're not in Australia.
I mean, if you want to suck my you can do it any time now. We can get this court order.
You're so smart.
You have to court order this.
You're so funny. You're so cute.
Can we get a court order to get my sucked, sir?
You're so cute. I know all the inmates just love you to death.
Oh, yeah.
Oh, I bet.
All the white butt boys love me to death, too.
Okay, well, I'll bet they do. And I bet all the rest of them do, too.
You ain't supposed to smile in court.
I'll bet everybody enjoys
That's
sucking.
a violation.
You ain't supposed to be smiling in court. That's a violation.
I can smile anytime my dad...
A violation of what? I want to know. A violation of what?
Want to.
Now you're yelling at me again.
I am. I'm yelling.
You're getting mad.
This is, I stress, this is verbatim coming from a transcript from an actual hearing in a Georgia state courtroom. This is a pretrial hearing in an actual courtroom in the state of Georgia. And they are basing this off of the transcript verbatim.
Can you hear me?
You're shaking.
I am yelling at you.
Well, reckon you can suck my
yelling.
Can you take a break?
Yelling.
Can you take a break?
I'm yelling at you.
Can you take a break?
Yelling.
Can I get my sucked?
Can you hear me? Yelling.
Can I get my sucked?
Yelling.
Are you ready to suck now? Have you got it all out?
You know something?
You will, but you want me to you in the butt then, right?
Oh my goodness. You've got plenty of that over in jail.
I can see it in you when I came in the courtroom.
Okay, that's fine. You're gonna be here on... Let me tell you how this is gonna work. You're gonna
You ain't gonna tell me shit.
Listen.
Suck my
Shut up. Listen to me.
Suck my you man.
Listen.
Suck my
You'll be here in the court on
You'll
Monday.
be here sucking my
Well, listen to me now.
yourself.
Okay, I'm going to tell you how this is gonna work. You either listen or not. I don't care.
I'm through. Can I leave the courtroom?
No, you've got to stay here.
No, I'm not talking to the bastard.
We're going to have the trial Monday week.
No, the we are. I ain't going to trial with this lawyer present.
Listen, if you do not
suck my you stinking ass cracker.
If you act like this, I will send you out of the courtroom.
Old bitch ass cracker.
And leave you out of the courtroom during the trial.
Horse ass cracker.
Do you understand
Horse
that?
Ass sucking ass.
Do you understand
big
that?
Butt,
Do you understand
man
that?
Ass cracker.
Do you understand that?
Getting mad, ain't you?
Stupid.
Red face.
Listen.
Now you're calling me stupid.
Listen.
And he's called. And he talks about how he loves white boys and he's calling the judge a cracker. But you see his mugshot, and this guy is just as fucking white as Robert E. Lee.
Yes, I am. You know what? You have a constitutional right to be a dumbass.
Why don't you jump up on the stand
You have a
and jump
constitutional
around
right
like
to be a
kangaroo, you dumb bastard.
Well, if you-
Suck my I ain't listening to nothing you say.
Come in here Monday
And
weekend.
how about this? I'll kill your whole family. And when I get
And now we get to less funny stuff when he starts threatening to kill this judge's family.
trial, I'll murder your whole family. I'll cut your children up into pieces. I'll knock their brains out with a hammer and feed them to you.
Are you taking this down?
Yes, sir.
Okay, I'm going to refer you to the district attorney's office.
I don't give a who
All right.
you're referring to.
I'm just telling you.
I found it. All right, I found it for you guys. Here is a link that'll get you the actual transcript, and you can see it for yourself. Here it is.
I thought you were referring to my mother man.
Aggravated assault, terroristic threats, and we'll just
I
add
don't give
to
a
it.
I will murder you, your whole family, your kids. I am not supposed to be in jail. I was framed. That mother asked me to eat his ass for a bag of coffee.
Well,
and
you
now
know-
you're telling me
What? He threatened to eat his ass for a bag of coffee. And again, I stressed from last night, was it Folgers or Bustelo? Because I mean that matters.
that I got to go to trial with this man over here.
You're obviously
He's probably a pedophile.
You're obviously fixated on butts and.
Huh? I'm fixated on your mouth.
No, you're fixated on butts and.
You got a nasty mouth, sir.
I have an awful mouth.
You have a big old fat mouth.
I do.
You gotta have a big old mouth to get this in it.
I sure do.
All right.
Yep, I'm proud of it.
I'll make sure the next time I come to court, I'll pull it out and jack on you.
Okay, why don't you do that right now?
I jack on white boys.
Well, why don't you do that right now?
Just like I jack on females.
Do it right now.
I can't do it now.
Do it now.
I ain't got.
I don't care.
Take off the cuffs.
Wait, I thought he wasn't into females.
How many hands do you have to do it?
Take off the cuffs.
Come on. No. Jack off.
This is kangaroo court.
Come on, jack off.
This is kangaroo court.
Jack off right now.
Are y'all getting this?
Yeah, they're getting it.
I'm gonna make sure this guy done called me stupid. This motherfucker done told me he was gonna suck my.
I did not say that.
You wanted me to him in the butt.
I did not say that either.
You're a real nasty ass judge.
I am indeed, and you're going to find out how nasty I really am.
You'll find out how nasty I am when I murder your whole family, bitch.
Okay, that's fine. You know, you'll be in jail so long you won't have a chance.
The babies will be going, Daddy, help me. I'm just going to knock them.
Okay, did the court transcript actually point out that he laughed at that? Hold on. Oh no, it does. The transcript does not say that he like starts laughing. It just says that babies are going, Daddy, help me. I'm just going to knock their brains out with a fucking hammer.
Their brains out with the hammer.
Okay, well, you know, if I had any kids, you'd probably be able to do that. But since I don't have any, it doesn't really matter.
Well, then I'll get your nieces, your nephews, your sisters.
It doesn't really matter. I don't have any of those either.
Grandkids.
I don't have any of those either.
Aunties, aunts.
How can I have grandkids when I don't have any kids?
How can I have grandkids if I don't have any kids?
Brothers, sisters.
Stupid. You know, you're just completely have no idea of the English language.
You're not gonna suck my sir. I don't want to be here.
Okay, I've enjoyed this. I hope you have. I know everybody else in the courtroom.
Because I imagine everybody in the fucking courtroom was laughing their asses off too.
Has enjoyed it, but you can go now. And if,
all right, well,
if on Monday week this happens again, you will not stay in the courtroom.
Suck my sir.
Okay.
I'm subpoenaing y'all's ass in the courtroom.
Animation planning, writing, keyframing, drawing, rig building by this guy. And voiced by Stephen Serifus Kelly. That's it. One guy, Rick and Morty was one guy did the voice of Rick and Morty. And then Jessica did the voice of the bailiff. I'm actually okay with stouts. Like I said, the big, like, you know, no for me is IPAs. I can't say like I would seek out a stout, but I've enjoyed stouts. Let's put it that way. Have a good night, BL. See you later, man. Oh my god. Ah. Legal Eagle already reacted to this, damn it. And he got a million views. Oh well, I'm okay with it. He's got this YouTube thing down more than I do. It's all right. Oh. This will be the last one, I promise. This is the last one. Like I said, I'm going on vacation. I'm going to see my parents in Mississippi. My flight leaves tomorrow morning. I'll be back. I'll be flying back in on Sunday, and I will probably have a stream on Monday. So look forward to that. So I thank you guys again. I can't thank you guys enough. You know, ever since I was able to break that 1,000 mark, I've been able to get a lot of people watching, a lot of people paying attention and enjoying my content. I really appreciate it. I can't thank you guys enough for all the support you're giving me. You know, I hope to keep on going, keep on providing more breakdowns for you. I have like three, Deacon, I have like 3 masks in my bag, and on top of the one I'll be wearing to the airport. You remind me I need to change my filter. But thank you guys again. We're going to end it with Mr. DeWitt's sentencing hearing, because this guy really needs another one. But yes, thank you again for all the support. It really does mean a lot. It really helps motivate me to keep on going, right?
Mr. DeWitt, I wouldn't make any facial expressions or motions or anything. You have an attorney who's capable of arguing whatever they need to argue for you. Statements.
I understand.
And then
that,
the judge who signed the capias. Mr. DeWitt, if you can't behave and conform, then we'll remove you.
No,
okay?
Your Honor. I'm sorry, Your Honor.
So,
my concern is this. I know we don't know anything.
Within 30 days, if you cannot afford an attorney.
This will be my first flight ever since all this craziness began. So,
Dan, you're here for Mr. DeWitt.
Yes, Your Honor. I'm here on behalf of Mr. DeWitt.
Okay, and Mike, was he already seen on the other? Oh, because he was our ward, so he wouldn't. Okay, so he wouldn't have been seen by that.
Right.
Can you just state your name for the record for me?
Yes, Your Honor. It's Jeremy Charles DeWitt, Your Honor.
All right, Mr. DeWitt, looks like you came on the docket because you have a number of out on release cases, and so that's why they held you, even though you were our ward on the new law.
Yes, Your Honor.
And so, I don't know.
Your Honor, the state is
Can
requesting
you
that
just
Mary Lynn Honeymeyer for the state. The state's requesting that the defendant's bonds be revoked on his 3 prior cases.
How can I revoke bonds when the offense date occurred?
This offense date occurred afterwards, Your Honor. The defendant was arrested on September 7th, 2019. When the defendant was here last time, the defendant misrepresented to the court that all these offenses happened prior to the 9/7 offense date. That is not the case. So the first case he was arrested on was 2019 CF 12733.
Right, and he was seen by a judge on the 8th, correct?
Yes.
Okay.
And then the case for 2019 CF 15055, the offense date for that was September 16th, 2019.
But he hadn't been seen by a judge.
And that he was not
Thank you.
arrested at that date, but that was when the felony offense took place. He was then seen by a judge when the defendant represented to the judge at initial appearance that this 15055 case happened before. It did not happen before. And this case that he's here on, 20 CF 1853, happened on October 1st, 2019. So again, after the September 7th, the cases where he has been out on bond, when he was seen by a judge on September 8th, he was on release for that. and he has consistently picked up new law offenses since that September 7th date.
Well, I mean, I understand that I could revoke on the 19 case. I don't know how I could revoke if he hadn't been seen by a judge
So that would mean
for this offense, because the new law offense is alleged to have occurred.
I see that. I saw that, Wazoo.
Yeah.
Adoption
so,
papers.
So the state would be requesting that his bond be revoked on the one that he was out on bond for.
Because you said bonds.
Sorry, Judge.
Okay, all right. Because that's why I was trying to figure out what you meant. Because
Yes.
I don't think I can revoke on the other cases.
The other ones, Your Honor, the bonds can stay the same, but the one that he was out on bond for at the time, the 2019 CF 12733, the state is requesting that that bond be revoked.
All right, Mr. LaJohn, do you have any argument?
Yes, Your Honor. So
So my understanding is that while he was out on bond, he was arrested again for impersonating a police officer.
I agree with the court's analysis and was going to raise that issue, but it's been resolved, so I'll pass to the next issue for me. All of these cases flow from video that was taken from my client as a result of his arrest in Windermere. We're not.
Well, the ones that I'm giving them are the greenies, feline greenies that are like catnip flavor, but I usually get them the chicken.
Not here to litigate that case, but for the court's consideration, one of the main elements of this offense that's alleged is that my client intentionally intercepted conversations. And what I think it's important for the court to understand for today's purposes is this. Mr. DeWitt operates a business that uses body cameras. Those body cameras are on all of his uniformed personnel that operate these funeral escorts. Those body cameras are always running. So in the event that law enforcement obtained these videos and is now going through systematically to find what else they can potentially charge my client with, what they're finding are those recordings. And so the issue of intent is really what's at stake here. I don't know that there's any way we're going to get to the bottom of that today, and don't expect the court to make that assessment. But I think before you revoke this man's bond and keep him in jail, I'd like you to at least consider the fact that that is the source of this audio. And
Isn't this a recorded phone conversation?
correct, but anytime it's a helmet cam and a body camera. So anytime it's running, if he makes a phone call, it's going to record it.
Your Honor, if I may, I don't believe that this was body-worn camera footage that was recording
Yeah,
in this case. I have seen the audio of it. It isn't from the defendant's body-worn camera. That's my understanding. So I understand what the defense is saying, but that is an argument to be made not of whether or not his bond should be revoked, but an argument of whether or not there's PC, which has already been found, essentially.
Okay, because I mean, based on one of the affidavits, it says that I reviewed the.
Like, okay, why is he doing the whole body cam gesture thing? I'm pretty sure the judge knows what a body worn camera is. Yeah.
Above mentioned disc that they received from Chief Edwards, which he obtained from Detective John Allen with the Windermere Police Department, and the disc contained an audio file of a recorded phone conversation that took place on October 1st between a person who identified himself as the defendant, a crime scene analyst, and the individual.
I have not cooked my cats a meal, and I have no intentions of doing so for that. I love my cats, but I am not going to actively cook them a meal.
Looks like Gregory Fosterino. So I don't know whether, Mr. DeWitt, I wouldn't make any facial expressions or motions or anything. You have an attorney who's capable of arguing whatever they need to argue for you, okay? So I don't know if it's a body camera, helmet, whatever is being recorded, but it appears as though it's some sort of a recording of an audio file. What?
Our third. It's our first baby, but our third chance.
She's had 2 miscarriages previously, so there's a lot of medical issues going on at home. There's a lot of stress that's related to the pregnancy in light of the prior miscarriages. So while that's not, necessarily an issue
Winamp. It really whips the llama's ass.
Of the lawfulness of revoking the bond, I do want the court to at least be mindful of where he is and what we're trying to do. Mr. DeWitt has not done anything in months to do anything in opposition to the law. I'm monitoring everything that we're doing on these cases, and they all do have a potential issue based on what Windermere did in that first case, which we'll be litigating, but it's going to take time and money and effort to do those things, and none of those things are going to happen if he's in jail. So I really need him to be out.
All right, any last argument?
Your Honor, so the state's argument is that the defendant has violated his conditions of pretrial release and that there are no conditions of release that can reasonably protect the community from risk to physical harm to persons. The defendant is continuing to be a risk to the community. His business practice continues to be a risk to the community. The defendant is consistently picking up felony charges while out on bond. The defendant's bond should be revoked for those reasons.
Okay. So you can file a motion to revoke bond and let the trial division determine that, but I'm not going to revoke his bond today. And so you have motions that you can file, but I'm not going to revoke the bond based on the affidavits, because I really don't know where the information came from and when it came from, and I just don't feel comfortable doing that because I don't know enough. So, but you have the opportunity to file any appropriate motions in the trial division, and looks like the only case that the bond could be revoked on would be the 19 CF 12733, based on the dates of the offense, possibly the one in Osceola County, which I'm not going to take any action on that either. That's 2019 CF 3928. So it looks like there's two cases that possible that a bond could be revoked on, but I'm not going to take any action today. Okay?
Yes, Your Honor. Thank you.
Thank you very much, Your Honor.
All right.
So he doesn't even get, so he still has his bond, or is able to get on a bond. Okay. I know I said I was going to stop here, but D-Gen's latest video is fucking hilarious, and I have to end it here. Because this Karen sounds like a fucking drill sergeant, and somebody else calls her out on it. I can't help it. It was funny as hell.
Help me! Get off the steps now! Oh God. Somebody help me! I'm possessed! I want the camera out! Who gave you permission? I need your names!
Yes, Drill Sergeant!
Who gave you permission to film?
The way she says it is fucking amazing.
Who gave you permission?
Who gave you permission to record here? I need your names, Private.
Your names.
Drill Sergeant.
Who gave you permission to film? Get off the steps.
What you all are
She seems a bit nettled, I think.
witnessing is a hangry Karen run.
If you don't shut up, I'm calling the police now! Call 911 now! You know what, asshole? Since you insulted my kids and family, call the police now! No, give me the film and the camera! I've had it with you photographers that bid on me! No, you just did an illegal phone thing. You always work here alone. What's your name and number, Norma K? I'm
Norma K?
tired of being beat up by people, like photographers who use the photos against people. What are you talking about? I want, and you threaten me. You come here all the time. I have never been here in my life. That's a lie!
That's a lie!
I'll tear your mind out. I'll burn your soul.
I mean, I would say her initial, like, outburst sounded, at the very least, like a Hollywood version of a drill sergeant. Like, Arlie Emery type shit.
That's a lie!
What's up, Tammy?
You remember seeing me?
Yeah, I do!
You're a liar. You're a
No,
liar.
I'm not!
I have never been here in my life.
That's a lie! What's your name? What's your card? You're a photographer! Give me the card! Give me your card! You're here, Dairy Queen, get out!
Dairy Queen?
Everybody has a card.
They're at a Dairy Queen?
Card! Calling card!
Why do you want a calling card? You're on the call. You're a calling card.
Don't smart to me, you did before!
Yeah, I did, really. Oh, dude. You've never seen me before, lady.
I'm calling the police because it was an illegal thing to do.
Do you work there, or are you just looking out for no reason?
You've been told before not to come! I'm calling the police! Yes, I have! You come here!
They stay in shape till a point. It is scary.
Every couple of years they take illegal
Fair point.
photographs! Yahoo! I'm cuckoo for Cocoa Puffs! What's your name?
Is it illegal to photograph? Have you ever heard of
That's illegal what you guys do!
what? What do we do?
You argued with me before. What's your name?
What do you do?
I'm calling the police.
Sorry. I mean, we don't mean to make
I'm calling the police and everything. No,
all right, fair enough.
always mess around. What's your name?
What do you want? What in the fuck is the problem?
I want the film! I want the camera!
Tell me!
Because
what we
you're
did.
not allowed to trespass! Get away from me!
What did we do wrong?
You're one trespassing!
Okay, here's what they did wrong. 1, trespassing, which she can't really say that if she's not the owner of the establishment.
2, illegal photographs!
They're photographing in a public space, as far as I can see.
3, you're not allowed!
That's just simply her declaration that they're not allowed to do that.
4, you've been yelled at!
And being yelled at is not a crime.
Are you sure about that?
You grow up! You're illegal photographers! Get out!
Illegal photograph. Excuse me, go up, man. Go up.
Illegal photographing, trespassing!
Go up real quick.
Okay, now you've narrowed it down to 2 things.
Are you an Aborigine?
You have insulted me before! You know what you guys do? You take illegal photographs and insult!
Inside voices. Thank you.
Yeah, you should! You guys beat on me before!
I never.
Wait. Peed on her?
Yeah, you did! Get off the property now!
I peed on you? You own this property?
Get off now! It's illegal photography!
Sorry for the hassle.
No, you're not! You'll do it again till I do something to stop it!
Hey, they're just trying to escape. Like, we're not trying to make you mad. I'm sorry.
Get off!
We're leaving. We're leaving.
You want to give me your name so you explain your story?
Yeah, Jeffrey.
Jeffrey what?
Hamilton.
Jeffrey's a you photographer?
Yes.
Give me your card! You can't take photography there!
Why not?
You can't!
You can explain to me the law? I don't understand.
No, you understand the law, you take advantage.
Okay.
Are you related to that lady?
Yeah.
I don't know what she's saying.
You're speaking too loud.
Well, that camera just came out, and he's the
No,
one taking
I don't
pictures
want
for about
to listen
a
to your
year.
lies. Jeffrey, what do you want right now? 'Cause I'm tired of being yelled at by you. And then
I want to know what we did wrong.
you take enough photographs of me on that right now?
Okay, sorry.
All right.
This next.
That was it. All right. I'm the other one is whatever, but I got a kick out of the way she was screaming. I thought it was hilarious. All right, we're done. I'm officially now done. Okay, again, going on vacation, heading out to see my parents and my brother in Mississippi. I will be back. My flight comes back on Sunday, and I'll be back at it on Monday. We'll see what happens, whether or not I'd stream on here on my other channel. I kind of want to stream on my gaming channel. I haven't done that in a long time. So if you are interested in me gaming, me struggling on Sekiro, or me screaming like a little girl on Phasmophobia, check me out on my other channel. Beyond that, thank you guys again for all your support, all your love. I really appreciate it. Thank you so much. Thank you for all your well wishes. And I will see you guys. Take care.
Archer, come here. Archer! Stop being a bad kitty! Hi.